Well, good evening, everyone. Welcome to the New York City Bar Association. My name is Michael Cooper, and I'm the chair of the United Nations Association, the United Nations Committee here at the association. And I wanted to welcome you here this evening. We have really what I think will be a fascinating panel that is tied in with the 60th session of the commission on the status of women. A very interesting discussion tonight. My role is essentially to introduce our moderator and also to tell you a little bit about the SDGs. I can say as well that some of you may know that I'm just stepping into this role of chair of the United Nations Committee here at the New York City Bar Association. In fact, this is the first event that I have the honor and privilege of speaking to you as chair from this podium anyway. And one of the great benefits of being the chair of the United Nations Committee is that I get to take a great deal of credit for things, events like this, for which I've actually done quite little, in fact, to produce. The two folks who have really been the driving heart behind this particular event are, first of all, I'd like to introduce Caitlin Thomas, who is the former chair of the United Nations Committee here at the New York City Bar Association. She's played a big role in bringing us together this evening and inviting many of our speakers, and also Cynthia Rawlings, who I'm about to introduce. But before I do that, I just want to say a couple words to you about the Sustainable Development Goals, if in fact you may be unfamiliar with them. So back in 2000, the United Nations adopted something called the Millennium Development Goals. There were about 8 or 9 goals, and they were very specific targets that the world community sort of got behind and tried to achieve. And in fact, we made pretty good progress on achieving a number of those goals, and it proved to be a very good framework and paradigm for advancing the development agenda. It really helped to focus investments and innovation and institutions and individuals on a specific set of goals. At the same time, those goals were criticized for a number of reasons. Probably the main reason is that they were adopted in a way that was, we can say, not very inclusive. So not very many people were asked what they thought the goals should be to begin with. So after 15 years of working through this Millennium Development Goal structure, it came time to negotiate a new set of goals, and there was a big push for a much more inclusive process. And indeed, there was a more inclusive process. Member states were quite actively involved. UN agencies were involved. There was a big survey called the My World Survey where folks could online indicate what they felt were the most important development objectives. And there was even an effort to go around into places around the world where there was no access to the internet. So to march into villages where you go 2 or 3 hours on foot to reach folks and do surveys by hand so that we could really get a sense of what people thought were the most important things that could really affect their lives and lead to a better developed world, sustainably developed world. And there were millions of people that responded to that survey. I don't remember the exact amount, 8 or 9 million, I think, in the end, responses were collected. So for me, there are a couple distinguishers between the Millennium Development Goals and the Sustainable Development Goals that I'd just like to quickly point out. So the first is, as I mentioned, that the negotiation around the two sets of goals were completely different. One was rather exclusive and the other was much more inclusive. The second thing I'd like to point out is because the negotiation was more inclusive the second time around, of course the goals themselves are more inclusive as well, and they cover a lot more territory. So in fact, there are 17 separate Sustainable Development Goals. There are 169 separate targets, and we don't even know how many indicators underneath the targets there are right now. So it's a much more comprehensive approach to development. In the past, it was sort of this myopic view of if we focus energy on just these few things, we'll get the job done. Now I think there's an understanding that we need to focus energy in a lot of places all at the same time and have this more comprehensive approach. I guess the last thing that stands out in my mind is that the Millennium Development Goals were really focused on developing countries, whereas the Sustainable Development Goals are considered to be universal. So they apply not only to developing countries, but also to developed countries. And in fact, not only to countries alone, but to international institutions, to corporations, and to other sort of entities that we have in our lives, maybe even bar associations, if you will. The idea of having a more transparent and accountable and participatory processes, for instance. So having said that, I hope that provides enough of a framework for tonight's discussion. I just want to briefly introduce you to Cynthia Rawlings. I've known Cynthia for a number of years now because we've served on the committee for several years. She is a partner at Beldock, Levin, and Hoffman, and I had known that she had a strong history in employment law and discrimination and civil rights and those sorts of things. I didn't realize, though, when you have to introduce somebody for the first time, you really take a look at their CV, and I'm really impressed by a lot of the First Amendment work that you've done over the years, Cynthia. If I remember right, there was a particular case mentioned on your profile about the Declaration of Independence as well. And maybe I'm conflating things here, the First Amendment and the Declaration of Independence. So I think one came before the other, right?
Those two were unrelated.
Right, okay. So that helps me to put it together in my mind. But at any rate, it's been a great honor and privilege getting to know Cynthia over the years. And I'd like to turn the floor over to her and to ask her to moderate tonight's event. And I will join you in the audience if that's okay. Thanks, Cynthia.
Thank you, Michael. I think my real function here is introducer of our distinguished panelists. As Michael just said, I'm a lawyer here in New York who has labored for many years trying to address issues of discrimination and civil rights violations domestically and to some extent more recently on an international level. The panel tonight is focused on obstacles faced by women globally in attaining sustainable development goals. And each of our panelists will address different issues and obstacles faced by women, including violence against women, enslavement of women, denial of reproductive rights in healthcare, and entrenched political inequality. It's my great pleasure to introduce these accomplished women, all of whom have been working hard to address these obstacles faced by women around the world in our continuing effort to achieve equality and empowerment. A few ground rules. Each of the panelists will speak for about 15 or 20 minutes. I think there are a couple of sets of PowerPoints. They will speak one after the other. After they have concluded their remarks, I will turn over the floor to Caitlin Thomas, who may add some thoughts and ideas of her own and who may have questions for the panelists. And after Ms. Thomas speaks, then we'll open the floor to questions from the audience. For your information, the program is being recorded and will appear on the Bar Association's website. Our first panelist is Janet Benshoff, whom I met decades ago in Brooklyn. She's president of the Global Justice Center and an internationally recognized human rights lawyer who has established landmark legal precedents on women's reproductive and equality rights and gender crimes, among many others. Prior to founding the Global Justice Center, Ms. Benshoff was the founder of the Center for Reproductive Rights, the first international human rights organization specializing in reproductive rights. Under her leadership, the center established projects in over 40 countries and won major constitutional cases in the U.S. Supreme Court. Before that, as if that weren't already enough, Ms. Benshoff was director of the ACLU's Reproductive Freedom Project, where for 15 years she spearheaded litigation on gender equality and reproductive choice. In addition, she has advised women from Burma, Kurdistan, and Iraq on constitution drafting and has conducted human rights trainings in Iraq, leading to a precedential decision in which the court adopted the gender crime standards of the ICC and held officials guilty of rape as an element of genocide, crimes against humanity, and torture. She lectures globally and has taught human rights law, has authored numerous publications, and has appeared on all major networks. She is a member of the Council on Foreign Relations. She's been named one of the 100 most influential lawyers in America and is the recipient of numerous awards. In her current role as president of the Global Justice Center, she focuses on using international law to implement and enforce gender equality and criminal accountability during conflict. The center recently filed an amicus brief at the International Criminal Court in support of the petition of Yazidi groups that the ICC open an investigation of ISIS genocide of the Yazidi and that gender-based genocide be one of the elements of the investigation. This follows a request by the center that the ICC include genocide of the Christian Chibok schoolgirls in its investigation of Boko Haram in Nigeria. Ms. Benshoff will discuss this work and the politicization of genocide and its disparate impact on women. Welcome, Ms. Benshoff. Thank you for coming. Karen Hanrahan, seated to my right, is currently the Chief Program Officer of the Center for Reproductive Rights. She's the former Deputy Assistant Secretary of State for the U.S. State Department's Bureau of Democracy, Human Rights, and Labor, where she helped to shape U.S. policy and programs for Africa and South and Central Asia, including policies on sexual and gender-based violence, child soldiers, and counterterrorism. Previously, Ms. Hanrahan designed Secretary of State Clinton's inaugural quadrennial diplomacy and development review, which redefined the U.S. government's approach to diplomacy and development. She also served as the Chief Innovation Officer for the UK Department for International Development. Ms. Hanrahan has spent much of her career working in and on countries in conflict, including with the late Ambassador Richard Holbrooke, and serving as the State Department's Senior Rule of Law Coordinator in Iraq and Senior Consultant to the Iraqi Minister of Human Rights. Prior to this, she served with the USAID's Office of Transitional Initiatives in Iraq as the Senior Advisor on Human Rights and Transitional Justice. She also worked for the UN High Commissioner of Refugees as a protection officer in Afghanistan, including substantial work related to gender. At the Center for Reproductive Rights, Ms. Hanrahan oversees the center's legal and policy work in the U.S., Latin America, Asia, Africa, Europe, and at the UN, and its global and domestic programs, all seeking to advance the human rights landscape with respect to reproductive rights, health, and justice. The center has been at the forefront of litigation involving women's reproductive rights in several countries, including in the United States, in which it recently filed an amicus brief in the Supreme Court in opposition to provisions of the Texas clinic shutdown law. Ms. Hanrahan will address recent global trends in the field of reproductive rights and health and topical issues in the context of the SDGs, as well as the center's work in the Texas case. Welcome, Ms. Hanrahan. Shazia Rafi, seated to my far left, is the Managing Director of Global Parliamentary Services. From 1996 to 2013, she was the Secretary General of Parliamentarians for Global Action, known as PGA. PGA is a nonprofit, nonpartisan organization of elected legislators from over 100 countries that leverages parliamentary processes to promote peace, international law, gender equality, and reproductive health. Under her leadership, PGA successfully promoted the Rome Statute, establishing the International Criminal Court, played a significant role in the passage of the Arms Trade Treaty to regulate conventional weapons trade, helped to build international consensus for progressive legislation on gender equality and reproductive health at the Cairo Conference and the Beijing Conference, and mediated in conflict zones around the world. Ms. Rafi was PGA's first female Secretary General, the first Secretary General from the developing world and from an Islamic country, and the organization's longest-serving chief executive. Under her tenure, PGA became an influential player in the worlds of diplomacy, international law, and development. Previously, Ms. Rafi served for 5 years as the UN representative for the All Pakistan Women's Association and as a consultant to the UN Center for Transnational Corporations and the Women's Action Alliance. Ms. Rafi was also appointed by the UN Secretary General to serve on the advisory board of the United Nations Democracy Fund. Ms. Rafi has published as a journalist in numerous publications. She speaks at leadership conferences and advises university programs. She is bilingual in English and Urdu and proficient in French, Hindi, and Punjabi. Ms. Rafi currently serves as a consultant to the UN and other organizations on international political and policy issues involving women's rights. She will address women's political rights and representation in national and international political bodies. Welcome, Ms. Rafi. And to my far right is Vidya Sri, who will be our fourth speaker. She is a Human Rights Policy Fellow at the Carr Center for Human Rights Policy at the Harvard Kennedy School. She leads the Initiative on Violence Against Women, part of the Every Woman Everywhere Coalition, a group which examines the legal and implementation gaps in the global framework and advocates the enactment of a new binding international norm on violence against women. She's also the founder of Ganga Shakti, an organization that conducts research and raises awareness of the problem of forced marriage. Ganga Shakti provides technical assistance on forced marriage and delivers training to service providers. Ms. Sri is the author of Voices from the Frontline, a paper that draws data from surveys, case studies, and interviews with frontline responders on forced marriage in the United States. This paper was cited in an August 2014 resolution passed by the American Bar Association, which acknowledges for the first time forced marriage in the United States as a human rights violation, and was instrumental in the passage of the resolution. She's the author of the definition of forced marriage for the Encyclopedia of Sexual Violence and Abuse and other publications. She is also an advisory board member for a National Institute of Justice-funded study on forced marriage in the United States conducted by the Urban Institute. Her work has been covered by Thomson Reuters and Al Jazeera America, and she has been the focus of in-depth interviews on NPR and TV Asia. Ms. Sri will discuss the conclusion of the Every Woman Everywhere Coalition, that there needs to be a new international norm on violence against women in the form of a new convention or modification of existing ones. She will also discuss the recent report of Ganga Shakti and the ABA resolution on the subject of forced marriage. Welcome, Ms. Sri. And without further ado, I'm going to turn over the podium to Janet Benchoff, our first speaker.
Oops. Can everybody hear me fine? Great. Thank you for having me here tonight. I want to thank Caitlin for her hard work, Michael for his introduction, and Cynthia for her introduction, which I'm now going to change because I felt like the presentation as described in your program was not as relevant as I could make it, because I really want to talk about the City Bar Association as an agent of change globally and how it has been in that role in a project of the Global Justice Center relevant to the UN goals. So the subject of my presentation will be two examples on the UN goals, but it will be using international law as a tool for radical change. And when I say international law, I mean that the United States is part of the international community also. And when we look at women and various rights in the United States, you have to realize that there's more than one way to achieve goals. And one way to get the United States is to get all of its major allies to agree with you and beat up on them. So the premise of the Global Justice Center, which I founded in 2005, is that, yes, sustainable justice, peace, and security is attainable in this lifetime. And the only way to obtain sustainable justice, peace, and security is a progressive and permanent global rule of law. Now, you might say, what does that mean, a global rule of law? Well, I'll tell you what it means. It means that we believe that international law is becoming the new, with globalization, it's becoming the new currency, really, for not only economics, but politics, legal institutions, new countries, new constitutions, transnational institutions, regional institutions like the EU. And there's some indicia that are critical to a global rule of law as we envision it. It must be universal and enforceable. We want to take rights from paper to practice. What good are more laws if they're not being enforced? And it's only by enforcing laws that you can create radical change. And we're not talking about any kind of rule of law. We're talking about a certain kind of rule of law that's based on human rights and not opportunities for women or equal rights for women without more, but actually de facto gender equality in all political and governing institutions. That requires radical change. Now, what do we do as international lawyers? First of all, we don't just look at human rights laws. We look at all forms of international law, the Genocide Convention, customary international law, judge-made international law, the law on states' responsibilities, Security Council resolutions as binding international laws. And by looking at this panoply of tools that haven't been exploited at all in a very progressive way, we forge international legal precedents. We provide partners like the Iraqi women's groups on the ground who wanted justice from the Saddam rape crimes of the army, or the parliamentarians in the EU who have a very gender-focused agenda that want to move it ahead. We give them some strategies. And we seize opportunities to embed legal norms in conflict and post-conflict situations. So we have been working with women leaders in Burma. Well, I have been working personally with them for 14 years. And lo and behold, I think 3 of our partners are now in the parliament, the new parliament under Aung San Suu Kyi, and we are virtually working hand in hand in writing the new laws of Burma for women with an international law focus. We also turn soft policy into hard law. You know, I often thought before I formed the Global Justice Center that women get policy and men get law. I hate the word gender mainstreaming and gender policy because it all means sort of something very soft. So we argue that Security Council resolutions that on children or on women that reference international law are absolutely binding, those provisions. And there's very good law on this, but it hasn't really been enforced before. So thank you for introducing the UN Millennium Goals. There are 17 of them. The 2 Sustainable Development Goals that are most relevant to the work of the Global Justice Center are SDG 5 and 16. One is achieving gender equality and peace, justice, and strong institutions. And so you can see from what I've said before, our work fits precisely into those 2. I want to give you 2 case studies, how lawyers can work. And these 2 case studies apply to these 2 goals, and so I think you'll find them very instructive on how these goals are really need a strong legal backing so that the changes are permanent. They're not just a policy that will go away until the next decade. The first case study is the laws of war and the changing face of conflict. War is not like it used to be. War used to be male combatant versus male combatant across country lines using conventional weapons. That's not how it looks anymore. 90% of those injured are no longer combatants, but civilians, mainly women and children. Women and children, in fact, are deliberately targeted by rape as a weapon of war. The majority of women and children in armed conflict who are impregnated by war rape are children, girls under the age 18. Children have special rights under the Geneva Conventions, which have never been associated with addressing war rape. Women and girls suffer more deaths and injury from war rape than from the use of any other unlawful tactic or weapon under the laws of war, like chemical weapons, for example. So rape used as a weapon of war is an unlawful weapon, and it creates more injuries and death than the use of any other unlawful weapon in today's armed conflicts. The case study I'm going to look at is that female war rape victims are routinely denied abortions in humanitarian facilities in all conflict areas in all 25 countries that are in armed conflict and covered by the Geneva Conventions. Now, for the Global Justice Center, a small NGO, we want to take projects on that we can win. And as you can see from this slide, I consider the Geneva Conventions low-hanging fruit. Everybody believes in the Geneva Conventions, you know, that you get a leg up instead of saying CEDAW or rights of the child. And the Geneva Convention, there's an absolute right of all war victims, all persons wounded and sick, civilians, soldiers, men, women, to non-discriminatory medical care, all the care they need to improve their health. Domestic laws are irrelevant to the Geneva Conventions. Geography is irrelevant. The medical care given a woman in one country raped in armed conflict has to be the same standard as in another country. Unlike the Geneva Convention's mandates, providers of medical care follow the abortion restrictions that are in conflict countries. That's a violation, a grave violation of the Geneva Conventions. As I said, there's a global consensus on the Geneva Conventions. The U.S. State Department, and Defense Department worked together, and the Department of Defense issued its first volume, 14 years in the making, of the international laws the United States considers binding on the United States, customary law, treaty law, under the laws of war, this June 2015. And everything I'm arguing there on the Geneva Conventions is confirmed there, that they forbid any kind of discrimination, that they prevail over any kind of domestic law. And of course, under Charming Betsy, if any of you remember that precedent from law school, United States laws, such as the Helms abortion restriction, are supposed to be interpreted to be compatible with international law. I don't know why it was Charming Betsy, but it must have been some ship anyway. So in this campaign that the Global Justice Center decided, well, nobody's argued that. We want to see that the whole world, in every war zone, provides every woman, every girl raped in war with an abortion, not as a charitable act or a policy or gender mainstreaming, but as an absolute non-derogable right under the laws of war, under the Geneva Conventions. And this is what happened. In 2011, we started this campaign, and our first partner was Norway. Norway stood up to the United States and said women raped in war essentially have rights under the Geneva Convention. The United States can't have a Helms Amendment funding aid for war victims that puts an abortion ban on. Following Norway giving us kind of the confidence that this legal theory would be adopted, I went to the City Bar Association. And the City Bar Association was the first of now nearly 4,000 groups who've agreed globally that the Geneva Conventions cover abortion. The City Bar Association in March 2011 wrote to President Obama and said that he must lift the Helms Amendment abortion ban insofar as it was applied to war victims. And I put a quote down there from the City Bar letter, which said, states have an obligation to provide non-discriminatory medical care to the wounded and sick under Common Article 3 and the protocols. Now, following the New York City Bar Association, we sent the letter around, and the Paris Bar Association filed identical letter. Of course, they didn't attribute it to the City Bar, but it came after. The Norwegian Bar Association. We got the head of every chamber, Queen's Counsel in the UK, to write President Obama this. We got the 55 UK parliamentarians. We got the International Federation of Women Lawyers, South Sudan, European Women's, German Women Lawyers, West Africa Bar Association. Now, these are just some of the more legal groups. Like 4 years after the City Bar came aboard, we got Human Rights Watch and Amnesty. In 2015, we've achieved our goal. Not implemented yet, not enforced yet, but there is a global consensus that women victims of war rape are within the Geneva Conventions, and abortion is necessary medical care, especially, as I said to you, children are the main persons who become pregnant from war rape. So we've gotten language supporting international humanitarian law, mandating care that has termination of pregnancy included in options for war rape victims, in 3 Security Council resolutions, in 5 or 6 UN Secretary General reports on women, peace, and security. The UK government had a debate in the House of Lords. We partnered with several QCs who were also in the House of Lords and others in the House of Lords, and they had a debate in which the government came to answer. And this was all set up, of course, but there is a debate. It's a wonderful debate. And the government stood up and announced they were changing their policy. And the UK government became the first government to say, our policy is that in countries that are in armed conflict, Geneva Conventions apply, and all of our aid must go for abortions under the Geneva Conventions, regardless of the local abortion law. And if our aid supports denial of abortion in any war zone, in any facility, that can be an act of torture under Common Article 3. After we got the UK, we got the Netherlands, we got France, and we got, well, as I said, then we got the EU. So the EU was a new strategy because President Obama, meanwhile, has done nothing. And so what do you do about the fact that the US is the biggest provider of humanitarian aid, and this virus of a ban on abortion goes on every single medical provider in a war zone that gives aid to girls and women raped in war? It goes on the UNFPA, it goes on the Red Cross, it goes on Save the Children, it goes on countries. So we couldn't get Obama, as of yet, to write an executive order, so we decided to render Obama and the US position rather impotent. And how can we do that? Well, if you look at the facts and figures, the EU and the member states together give much more humanitarian aid than the United States, and there's no major provider in any war zone, such as the ICRC, that doesn't get EU funding. So if we get the EU to put in an anti-Helms Amendment in their budget, then if people want EU money, they're going to have to provide abortions, and they're going to have to segregate out the United States funding, and we got it. So the new EU position is that female war rape victims, their medical care is governed by international humanitarian law. They can't be prohibited or denied abortions for any reason, including the varying abortion laws in conflict countries or the imposition of anti-abortion ban on humanitarian aid by the US. Now, what's interesting is this was not only, we embarked on a huge campaign, it took a lot of work, but we got this, but we also got language in the EU 2016 budget. On the section on commission aid, which is like billions of dollars, we have that EU humanitarian aid must follow international humanitarian law, no adverse distinction on women, and no imposition of other standards by another donor partner. Excuse me, you know who that is. So that's case one, and I think it's a very good example of how the City Bar took a critical role in making a legal change that really affected women, that affected the United Nations, and that actually moved countries. Now, case study 2 is more abbreviated. How much time do I have?
So interesting. Keep going.
Case study 2 is something that we're kind of launching, and so I can't reveal all of our intricate strategies yet, except we welcome the City Bar Association. And it's really about this counterterrorism move. It's another changing face of conflict because we have counterterrorism committees, money, political will, combating violent extremism, but where is international law? Particularly, where is the Genocide Convention? Where is never again when there's no question that ISIS is perpetrating an ongoing genocide against the Yazidi people and Christian people, an ongoing, and in doing so, perpetrating every single crime that's explicitly listed under the Genocide Convention. Well, what's also very interesting is the Genocide Convention is gendered from day one. I mean, it took us a long time to get rape to be considered as grave as to be a war crime or crime against humanity, but the abductions and enslavement of Armenian women and children, the seizing of Polish children, all these were in the mind of the drafter, Lemkin, of the Genocide Convention in 1948. So when you seize women or children, forcibly transferring children of a group to another group, now that means girl children too, that's an explicit crime of genocide. When you are imposing measures designed to prevent births within the group, and that's what ISIS is doing also because they're forcing abortions on Yazidi women and girls who are already pregnant, and of course then they're deliberately impregnating them and having them carry to term when it suits them, and they're not going to sell them, then they abort them then. So they're definitely doing these 2 crimes out of the 5 crimes of genocide that are explicitly prohibited since the convention went into effect in 1952. Now, guess how many prosecutions there have been since 1952 for these 2 crimes of genocide that really protect and give rights to girls and women? 0. There has never been a prosecution in the history of the Genocide Convention. So that shows you that even these strong international laws that are explicit for women have never, ever been enforced. So we're working with Yazidi civil society groups, and we filed, as Cynthia said, we filed a brief with the ICC asking them to take jurisdiction. It's true that neither Syria nor Iraq are members of the ICC, but foreign nationals are 1/2 of ISIS fighters. Mm-hmm. And the majority of those foreign nationals perpetrating genocide crimes are from ICC member states. So ICC member state residents or citizens are perpetrating gender genocide crimes and other crimes of genocide. So our first task in this initiative is to get genocide recognized, because calling what ISIS is doing atrocity crimes or crimes against humanity hurts women. Genocide is a very special international crime. It is a crime to protect distinct religious and ethnic groups from being eliminated. It is to protect the kind of world we want, a world of diversity. Protect the world we want, which is a world marked by tolerance of other groups. So it can't be swallowed up by just saying atrocity, and John Kerry has now said that. I'll skip over we've put through a lot of evidence in our brief in the ICC, which you can access, showing how all the different gender crimes for women are crimes covered by the ICC. We also believe that the Genocide Convention requires suppression of genocide. You know, we talk about preventing genocide all the time, but what about when it's ongoing? We argue there's a duty to try to rescue those girls. There's a duty because they get fresh crimes of genocide put on them, imposed on them, perpetrated on them every single day. Mm-hmm. They need to be rescued. And that's part of suppressing genocide. So what attorneys are doing? Well, in mid-January, we started a campaign to get the UK to recognize ISIS and genocide. The UK's comment in answer to a question from a member of parliament is, we don't believe states should recognize genocide, that's for courts. So of course this inflamed me. And I wrote my friends in the House of Lords, one who's a very leading human rights lawyer and Queen's Counsel, Helena Kennedy. She's already helped push a private letter to David Cameron about this. I'm trying to get the UK Bar Association to get on top of this. And today, just before I came to this presentation, Helena Kennedy had an op-ed in The Guardian that said ISIS is committing genocide, and she said it's morally indefensible for UK not to say so. And she looked at the raping and preventing births and forced transfer and said they all amount to genocide. So that's how we worked with a UK legal partner to really highlight why countries have to face genocide and they can't bury it under calling what's happening a mass atrocity. Thank you very much.
Bravo. Thank you very much. I actually did read the communication filed with the ICC, and I recommend it to anybody who's interested in the subject. I think it's all very, very well done. Our next speaker is Karen Hanrahan.
Come up, or?
Yes, I think so.
Good evening, everyone. That's certainly a hard act to follow. So I want to thank you for inviting me. I want to just recognize one person in particular, Janet Benshoof, who you just heard speak, and thank her for her thought leadership and practice leadership in the field of international law and reproductive health and rights. I am a big supporter of hers, and she has really been a pioneer in this area. So I'm honored to be on this panel with her. I am Karen Hanrahan, the Chief Program Officer at the Center for Reproductive Rights. And the center is a legal and global advocacy organization that works around the world in over 60 countries to advance reproductive health and freedom. We work on a broad continuum of reproductive rights, from access to quality maternal care, contraception, and safe abortion services to gender-based violence and harmful practices such as early and forced marriage, forced sterilization, and others. It's a pleasure to join you tonight and to discuss the SDGs and accountability and what lawyers can do. This is a big focus of part of our work, and we care very much about it. So reproductive health and rights are basically ground zero for women's autonomy and societal development more broadly. They're at the core of a woman's ability to govern her own future and participate in society. Because women are uniquely able to become pregnant and still assume the majority of child-rearing responsibilities in most countries, their ability to control their reproductive health affects many aspects of their lives, from employment to education to participation in their families and communities. And their ability to be employed and educated and raise their families in turn impacts broader development goals such as economic growth and poverty reduction. Choosing when and if to have children and having access to safe, effective health care free from discrimination or coercion. These are basic building blocks of personal autonomy. These are fundamental human rights. However, even a very broad look at public health and human rights concerns around the world show us how far we have to go to make these rights mean something in reality. So not just enshrined in law, but also in practice. So just a few snapshot statistics to help bring that picture into focus a bit more. Over 200 million women and girls around the world have an unmet need for contraception. In Latin America and the Caribbean, 56% of all pregnancies are unplanned. The region has the highest teen pregnancy rate in the world, with about 2 million mothers between the ages of 15 and 19. Worldwide, 22 million women experience an unsafe abortion each year, and 47,000 women die from resulting complications. Today in South Asia, approximately half of all girls become child brides. Every single day, approximately 830 women die to pregnancy and childbirth complications, when at least 90% of those are preventable, would be preventable with access to adequate health care. 99% of these deaths occur in developing countries. However, even in developed countries, profound disparities persist. So here in the US, we have one of the worst maternal mortality rate in the developed world, with 1 in 1,800 women at risk for maternal death. And the overwhelming majority of these deaths occur among poor and marginalized women. One of the most important steps we can take is to acknowledge the scale on which women are facing abuses of their reproductive freedom around the world. And for this reason, it is truly significant that the Sustainable Development Goals contain specific language that address reproductive health and rights. The inclusion of several reproductive rights-oriented targets in both the goals on health and gender equality signifies landmark progress in terms of both formally recognizing that reproductive health remains a huge challenge for women around the world and demonstrating government's commitment to solve these problems. It also signals a global trend of recognition that in order to achieve gender equality, women need to have access to reproductive rights and services. So 2 of the 17 SDG goals specifically mention reproductive health and rights. I'll mention those here and then talk a little bit about some of the challenges that we see in overcoming implementation of these goals. So goal 5 is the goal directed at achieving gender equality and empowering all women and girls. Among other targets, it aims to eliminate all harmful practices, including child early and forced marriage and female genital mutilation. And it ensures universal access to sexual and reproductive health and reproductive rights. Goal 3 is aimed at ensuring healthy lives and well-being for all, and it sets out concrete targets for women's health, a reduction of the global maternal mortality ratio, and universal access to sexual and reproductive health care services, including family planning, information, and education, and the integration of reproductive health into national strategies and programs. So it's a ambitious agenda. If accomplished, it would certainly improve the lives of millions of women around the world and change the game for women's autonomy and equality. Unfortunately, we're concerned that without robust accountability measures attached to the SDGs and a significant focus on accountability, governments will not implement these commitments for a variety of reasons, ranging from a fear of empowering women to a resistance to change that challenges entrenched cultural practices, to religious ideology, to a general lack of political will. So although women and girls have seemed to make it towards the top of the agenda for many donor countries and agencies, they still lag behind in most countries where the change is needed the most. In order to overcome these obstacles to implementation, we all need to work on very innovative strategies around holding governments accountable to the SDGs. And as many of us know, accountability at a global level, particularly with multilateral instruments, is a major challenge and not always supported as rigorously as we would like. And this is where we currently focus our energy at the center. We have found that one of our most powerful tools for catalyzing and forcing accountability is the law. The law is far from the only lever to hold governments accountable, but it has proven to be catalytic to and a critical foundation of our work around the world. So to the topic of this panel, this is where lawyers can help, one of the many ways that lawyers can help. So as lawyers, we want to make things as concrete as possible. Our goal is to improve women's lives in the most tangible way we can. At the center, we've found that by applying human rights law to situations that used to be considered just facts of life and unfortunate problems of the poor, we've had a good deal of success advancing the recognition of women's needs as fundamental rights, which governments have legal obligations to implement and to realize. So a couple of examples. After more than a decade, last year we achieved a major victory when the Brazilian government publicly acknowledged responsibility and paid reparations to the family of a young mother who died in childbirth in 2002 as a result of being denied adequate medical care. It was the first time ever that a country paid reparations for a maternal death. The story revolves around a 28-year-old Aline da Silva, a poor Afro-Brazilian woman, died 5 days after seeking medical care at a hospital near Rio when she suffered a stillbirth and fell very ill 6 months into her second pregnancy. In 2007, the center filed a case against Brazil on behalf of Aline's family before the UN Committee for the Elimination of Discrimination Against Women for failing to guarantee quality prenatal care to women in the country. It was the first maternal death case to be filed with the committee, and when they finally ruled in favor of Aline in 2011, it was the first international human rights decision naming maternal health a human right. Despite the positive ruling, we had to be relentless in demanding a meaningful response from the Brazilian government, which goes to the point that the law is not enough. Finally, in answer to our advocacy, Brazil took important steps in 2014 to implement the ruling, both symbolically and financially. The government held 3 different ceremonies, one in which they paid reparations to Aline's family, to her mother. In Rio, then, at 2 different hospitals, there were public ceremonies in which the state acknowledged responsibility and placed plaques telling Aline's story. The UN Committee's decision has had reverberations around the world. In Africa, we were able to use Aline's case as an example to spur litigation and advocacy in other maternal health violations. As a result, we have now filed 2 different maternal health lawsuits before the Kenyan High Court. One case involves the illegal detention and abuse of 2 pregnant women who are unable to pay their hospital bills. This past September, the court ordered Kenya's Ministry of Health to end the discrimination and abuse experienced by women in public maternity hospitals and provide financial compensation to these 2 women. The other case seeks to hold the Kenyan authorities accountable for violating the rights of a pregnant woman who was verbally abused and severely neglected at a public hospital and forced to give birth on the floor, and then slapped and yelled at by nurses for doing so. This case is still under review by the court. So turning to another region of the world, we've also had strong results. I keep prompting the slides here, I'm sorry. We've also had strong results in South Asia using the law to advance reproductive rights, from access to contraception, to forced sterilization, to child marriage. As part of the Center's South Asia Reproductive Justice and Accountability Initiative, which is transforming the way governments are approaching reproductive rights in South Asia, we have helped train regional lawyers and held workshops for developing promising litigation throughout the region, from Pakistan to Bangladesh to India to Nepal. Late in 2014, we filed the first case affirmatively claiming the right to contraceptive access as a fundamental right in India. And now we're working to ensure that this case sets an important precedent for the whole region. This is exciting progress. However, we know that laws and litigation are often not enough to ensure that women and girls are able to realize their reproductive rights, and that accountability cannot be achieved through law alone. So our lawyers are also focusing increasingly on policy solutions and advocacy that shapes political will and drives implementation. For example, in a number of South Asian countries, there are longstanding laws against child marriage. However, as the statistics I mentioned earlier indicate, the practice still occurs with shocking regularity. In fact, unless we can get governments to enforce and strengthen these laws, estimates suggest that over 100 million South Asian girls will be forced into child marriage over the next 15 years. Recently, we collaborated closely with the South Asia Initiative to End Violence Against Children to implement the Regional Action Plan to End Child Marriage in South Asia, and to advance the Kathmandu Call to Action. which is a call for governments in the region to denounce child marriage as a human rights violation, to bring their laws in line with international human rights standards, and truly enforce those laws. 8 South Asian states have endorsed the call to action. In an important victory last summer, the UN Human Rights Council also welcomed these regional commitments and unanimously adopted a groundbreaking resolution to eradicate child marriage. Again, another government resolution that does not necessarily lead to exercising of rights in practice, but these are all building blocks towards helping women and girls exercise their rights in practice. So these are just a few of the ways that lawyers are working to shape norms that advance women's reproductive rights at national, local, and global levels, as well as ushering reform within the legal system itself. Another way lawyers can help ensure the SDGs are implemented, including in the United States, is by supporting litigation work of others, such as ourselves and other organizations who regularly file cases, supporting us through amicus briefs, working with us on cases or bringing your own cases, such as the case we just argued before the US Supreme Court over Texas's restrictions on abortion access in Texas. So contrary to the introduction, we did not file an amicus brief, we actually filed the legal brief, and the center, our center lawyer provided the oral argument in front of the Supreme Court. So in the end, we had...
I'm sorry.
Oh, it's okay. It's all right. There's a lot of information. In the end, 45 briefs were filed in support of our case, from medical experts to legal scholars to government agencies to business leaders in the state of Texas. The significance of these briefs goes far beyond our case. They present a wealth of information on how abortion restrictions harm women foremost, but also how they harm stakeholders across the nation. There's much more detail and much more to say about that case, and we're happy to talk with people at any point about the details of our US Supreme Court case that, where we just had oral arguments 2 weeks ago. But I will not take up time here to do much more of that. So I'm gonna end here. In the context that we've just talked about, it becomes all the more imperative that we marshal all of our resources from traditional legal practice to lawyers working on policy and advocacy to protect the basic rights and health interests of all women. And the SDGs provide us a helpful framework to do this. I think it is just the very beginning, and it's up to us to find new and better ways to hold governments accountable, better ways than have been carried out in the past. So thank you so much for coming and listening, and I look forward to the other discussions. Thanks.
Thank you very much. And I do want to apologize audibly for misidentifying your role in that case. When I obtained the information that I had and was preparing those remarks, I was wondering who in the world could be representing the center if it wasn't the Center for Reproductive Rights, and I should have gone into the case and checked and found out, and then I would have realized, and I'm very sorry about that.
No problem. It's okay.
Okay, our next speaker is Shazia Rafi.
Computer now, so that I can just put mine. Perfect. Thank you. Well, both are a very hard act to follow. I particularly like Janet's comment that women get policy and men get the law. So, Excellencies, ladies and gentlemen, thank you very much for inviting me. I'm not a lawyer, and I'm going to be talking about the challenges to women's political rights in the UN system, in legislatures, and how the legal profession can help. As you are members of the United Nations Committee, you're aware that the UN is essentially international policy based on law. It's a system of 260 treaties, conventions, agreements negotiated through the General Assembly conferences on a wide range of issues, ranging from political security, economic, and social rights. The UN also has a parallel interparliamentary system of almost over 70 organizations that are interparliamentary organizations, linking elected legislatures to each other and to the UN, as all these agreements need to be ratified by legislatures, and then implementing legislation needs to be passed by those parliaments, in which, of course, your community is very actively involved. In legislative politics, really, it is lawyers who are in charge. A 2015 report on the US Congress shows that 54% of senators are lawyers, and 36% of representatives also have had law degrees and legal profession. And the same picture is there globally. I'm originally from Pakistan, and in my country, not only are they lawyers, but they also are allowed to keep their private practices going. So several of them have actually used those law firms to protect each other and defend each other when martial law imposed cases on them. So there's a very sort of dynamic relationship between the lawyers' movements and the legislature across the world. Women, though, are the stats on women in Congress and in parliaments around the world are a little different. They tend to come to politics through the education and social service professions. They're much more community-focused. The issues that they have fought for when in the House tend to be focused on education, gender equality, reproductive health, economic parity. And unfortunately, these issues on an international level are not governed by treaty. Women are getting the policy, they're not getting the law. They are only governed by voluntary conference-based agreements. So whether one looks at the agreement of the Cairo conference, one looks at the platform from Beijing, one looks at any of these agreed by consensus, these are still principles and goals. The only exception was the Convention on Elimination of Discrimination Against Women, referred to as CEDAW, which was an international treaty adopted by the UN in 1979. It was ratified by 189 countries, which is a huge majority of the UN. It has languished, though, as the United States, the most powerful member of the UN, refuses to ratify it. And 26 of the ratified countries have serious reservations to CEDAW, particularly related to family-based matters. New momentum, I want to look back a little into the past. The new momentum for gender equality really started in the work related to the Beijing Conference, the Fourth World Conference on Women, in 1995. Where a global consensus was achieved on the principles of a woman's empowerment, her political rights, her reproductive health rights, her economic rights, her rights to be secure, essentially saying that women's rights were human rights. Hillary Clinton was one who said it, but it was really the conference itself which spoke very strongly in the Beijing platform on that. This work was started actually by a very feisty New York lawyer who was also a congresswoman, the late Bella Abzug, and I had the honor of working with her. She was the instrumental leader who started an international coalition for the women's movement, which until then had been very much a sort of Western feminist revolution. Bella persuaded governments that a daily meeting of what she called the Women's Caucus was an essential tool for getting consensus on all conference issues. I joined her in '92, and when I joined Parliamentarians for Global Action in '93, we did an agreement that for every meeting that they would do, we would add women legislators to that meeting at the UN. And that those women legislators, in addition to attending the Women's Caucus, would also be members of the official delegations on behalf of their governments, so that they could take the word that women were agreeing to the table. The Women's Caucus became a permanent institution at every UN conference. It is still today, with daily briefings, analysis of the conference language, clause-by-clause negotiations. That is how we worked on the abortion consensus in Cairo. It is now been a key tool to get consensus from both men and women on every treaty, convention, and agreement, the International Criminal Court, the Arms Trade Treaty, and the latest Sustainable Development Goals. If you Google it, you will see there's a women's caucus or a women's group related to each of these, which has been really instrumental in getting agreements. The interesting corollary was going on at the political level. Through negotiating for their equality goals through these conferences, particularly Beijing, women activists started to run for national office. At the time when Beijing took place, it was about 10 to possibly 11% women across the globe who were members of elected parliaments. The progress has still been very slow. 20 years later, the numbers still stand at only 22.6 in national legislatures. Women speakers are now 17.8%, women ministers 17.7%, only 6.6% of all heads of state, and 7.3% of all heads of government. Some countries, there's even been some regression. The world's largest democracy, India, the numbers have gone down to 12% because there isn't a quota. There has been an attempt in the UN system to say, how can we sort of make this entrenched inequality budge? And UN Women has launched its iconic campaign called He for She, which has a hashtag and Emma Watson as its speaker. It is calling for men to be real partners in gender equality, and I'm glad to see some men here. However, in the political world, unfortunately, power and visibility are a zero-sum game. There can be only one Speaker of the House, only one chair of a committee, only one Secretary General, only one president, only one prime minister. So positions are heavily fought for, and women have to play very tough to get them. Even within organizations, I organized the Beijing conference's parliamentary meeting. And after having done all the organization, my boss decided that he wanted to go instead of me. And I had to go over and above him, around him, to get him to overturn his decision. It was something I had to really fight for. And I was surprised to even be facing that at the end of 6 months of work on something that was my project. Leadership jobs are also 24/7, particularly political jobs. They take their toll on family life. At Beijing +5 in the year 2000, we decided to do something different. We asked the women legislators who came for a meeting here at the UN that we organized of 200 women legislators to share their challenges after having been elected, both in parliament and at home. It was a very sobering report. More than a quarter of their marriages had collapsed, and many were planning to quit after their first term. The male political spouse has still to join He for She. Now, we will see something interesting in the US in case Mrs. Clinton gets the Democratic nomination, where we will see a very powerful former president as the spouse. But it will be really interesting to see how he makes that transition to becoming the He for She. One effective tool at the legislative level has been a cross-party, well-staffed women's caucus. Lawyers' role in drafting legislation is crucial for women's caucus members because most women, when they enter the legislature, often tend to be the most junior members with the least amount of parliamentary staff. There are about 88 such cross-party, cross-issue caucuses across parliaments, and they are producing some results. In Pakistan, the first woman speaker, Fahmida Mirza, was the one who formed the Women's Caucus, which passed more laws on women's empowerment than any prior legislature. However, many of those laws lapsed in the next legislature because the elections moved towards the conservative right. And several of those women who had championed those laws brought them into the lower house. Both the lower and the upper house have to pass the law for it to become permanent law. Several of those laws have lapsed. In Kenya, attorneys work very intensively with the Kenyan Women's Parliamentary Association, KEWOPA, equal property rights, equal citizenship rights, 2/3 either gender rule in government bodies, even, according to the chair, Cecilia Mbarire, even our right to wear trousers in parliament is the result of the work that they have done, that attorneys have done with KEWOPA. However, despite all that effort in Kenya's parliament, it's still only 19% women, and this is despite the fact that political parties have nominated women to the nominated seats to try and add to the number. The European Union and the European Parliament have a pretty solid record in the area of gender equality. And part of it is, I think, I'm not a lawyer, but you guys are, that their system of law is a statutory system of law, which allows for much more prescriptive legislation, I understand. They have also mandatory national equality bodies, and in 2006 created a network of gender equality bodies to enforce implementation of the laws that they pass. The political party list system, which is there in most European countries, also makes it easier to get more women into parliament because essentially the party list is made by party bosses and they can be persuaded to both give a number quota as well as to ensure that women are not at the bottom of the list. It's much harder in the US, where the election is both an individual-based effort on campaign and where the campaign finance requirements are very high. However, the Women's Caucus still keeps trying. Rep. Carolyn Maloney, who led the US delegation to Beijing and is a leading member of the US Congressional Women's Caucus, introduces a bill every year for the Equal Rights Amendment and for ratification of CEDAW. But the caucus lacks both numbers and power to pull through. Women in Congress are still only 20%. And here, really, the New York Bar and the American Bar Association can do a lot to add to both advocacy and assistance to legislators in this country to pull through on this. I realize that making gender equality legally binding across national institutions and the economy are very hard. However, bright lawyers are capable of coming up with solutions everywhere. And I'm sure that when you put your mind to it, there are examples of things that can be done which are effective. I've been working a little bit in the UK lately, and one of the things that's a very interesting law that has just been introduced by their Women and Equalities Minister is going to be an enforcement of publication by 2018 of the gender pay gap by companies with more than 250 employees. And this is going to include not only salary, it also has to include bonuses, and it also has to include numbers in each position of how many men and how many women are being paid what. This is going to really be a game changer in this area of the gender pay gap. Now, the area where I feel not enough has been done, and it's there in the gender equality goals, is this issue of accounting for the unpaid care given by women in the home to family members, children, and the elderly. And just to give you a sort of, and this is one of the targets that is there, but to give you a sense of what this is. The gender pay gap is linked to this. The gender pay gap worldwide is on average 24% between men and women. In high-income countries over their lifetimes, women in Sweden and France earn 31% less than men. The figure is 49% in Germany and 75% in Turkey. These gaps are there because employers are tacitly assuming that the woman is going to take time out when she has children. She is going to need more flexibility. She is not going to stay for the 6 p.m. meeting. She's going to take care of the elderly. And so they are sort of almost gaming this by giving them less money. So this whole area can change once you have laws that require their unpaid labor to be recognized and monetized. At this point, the only country doing that is Norway. Every 10 years in the census, they require that individuals fill out the amount of time that they spend in care work. And it is beginning to change the dynamic of the care work as well. Australia is beginning to figure out how they're going to do this. They're going to be using opportunity cost. And it's interesting to me also what happens when leadership shows up. You know, in terms of international institutions, very few major institutions have women at the top. But when they do, things begin to change because a new normal starts to take place. When I was made Secretary General of PGA, it was an Affirmative Action Act in 1996. One of the first things I did was to change our staffing to be 40-60 either gender. 2 years after being appointed, I persuaded the board to change their own election rules to become 40-60 either gender. And today, 20 years later, those rules are still there. That has become normal. The IMF has recently appointed a woman as executive director. For the first time, the IMF is beginning to talk about the hidden GDP of the world, which is the unpaid care work done by women. And it adds anywhere from 25 to 50% to the GDP if you are applying it either at opportunity cost or at minimum wage. So one of the most exciting things that's going to take place this year, and I'd be happy to answer questions later, is that the UN itself is going to be electing a new Secretary General. And there are several of us, I'm part of a campaign called Woman SG, who are asking governments that this time we want it to be a woman. And here is something that actually all of you can do. There are 5 countries, the permanent 5 of the Security Council, who will be making this decision on a joint basis. The United States is the most powerful of them. It's often called P1. The president is a lawyer. So as lawyers, you should write to him and ask him to uphold the principles of gender equality and affirmative action. After 8 men, it's time for a woman. Thank you.
Thank you very much. For those of you too young to know this, Bella Abzug was a very vocal, very visible New York politician who wore very large hats.
Yes.
And the mention of her name brought a smile to my face. She was a force. Wish we still had Bella Abzug.
Absolutely.
Our 4th speaker is Vidya Sri.
So good evening, everyone. Amazing information, remarkable women that I have the privilege of being with today. I'm going to talk to you about forced marriage, specifically here in the United States, and I'm also going to talk to you about some very interesting work that we're doing along the lines of global gaps in violence against women. I think most of us here are aware that violence against women and girls is the most prevalent human rights violation. Let me give you some numbers. So globally, the most common form of violence experienced by women is physical violence inflicted by an intimate partner. 1 in 3 women have been abused or subjected to violence during their lifetime. In Australia, Canada, Israel, South Africa, and the United States, between 40 and 70% of female murder victims were killed by their intimate partners. And up to 70% of women experience physical or sexual violence from men in their lifetime, the majority by husbands, intimate partners, or someone they know. Worldwide, up to 50% of sexual assaults are committed against girls under the age of 16. And it goes on, and I'm sure many of you are familiar with these numbers. We're all familiar with the Universal Declaration of Human Rights, Article 16.2, where it says marriage shall be entered into only with the free and full consent of the intending spouses. We've also seen the UN Convention on Consent to Marriage, minimum age for marriage and registration of marriages, Article 1, which says no marriage shall be legally entered into without the full and free consent of both parties. And several of the speakers today have referenced the CEDAW, a very important foundational framework and a global standard, which clearly says a woman's right to choose a spouse and enter freely into marriage is central to her life and her dignity and equality as a human being. And reaching out to different communities, it was incredible the wide diversity of cases that we started getting. So Latin American, African American, Chinese American, Irish American cases. An Irish American young girl was 15 years old, became pregnant, did not want to get married. She was being beaten black and blue. She called us, not knowing what to do. They forced her into marriage, and her husband started beating her even more. She lost the baby, and he left her, and he said, "I never wanted to marry you in the first place." So again, an illustration just to share with you that something like child early and forced marriage takes on many, many different shapes and forms and permutations and combinations. And one of my goals here today with you is to really help us to think outside of the box, and not put issues like this sort of on a shelf and label it. So here are some definitions of forced marriage. Really, the way I see it, after sort of getting a huge number of cases and consulting with a very, very large number of frontline practitioners, is that forced marriage is a marriage that has an absence of consent from one or both parties and uses one or more elements of coercion, violence, or fraud to cause the marriage. So to be very clear, I see one of those three elements or all of them used to cause the marriage, not necessarily something that happens after the marriage takes place. Some of the causes of forced marriage, you're probably familiar. I'm not going to run through all of them, but suffice it to say that these are very common causes that we have run into here in the United States. And we're talking about second generation, third generation. We're not necessarily talking about someone that might have recently arrived to this country. And I want to point out the very last bullet, this concept of controlling the chastity of an individual seems to be very common and very predictable, regardless of ethnic background, regardless of religion, and regardless of that wonderful word culture. So I would just like to really stress that point. I don't like this phrase, so-called honor violence, but I'm sort of compelled to cover it because it is used in the vocabulary of forced marriage. I don't really care for it because it's a very confusing phrase, and I think it's been extremely misused in some instances to vilify certain communities and certain cultures. Because if you really think about it, all the different ethnic backgrounds that I listed off to you, every single one of them believed that they were protecting the honor of their daughter. So, this is, if we're going to use it, we need to use it for everyone and not for certain communities. But, there's some bullets there that talk about what so-called honor violence is, and it encompasses a very wide range of crimes. Arranged marriage, I think it's important to point out, again, here in the U.S., we continue to conflate arranged and forced marriage, and they are very, very distinct. Arranged marriage being a very mainstream, common, very safe way of bringing two people together that's been practiced for millennia. There's typically no violence and trauma. And I think it's really important to stress that it's a very, very, very different type of marriage than a forced marriage. So I've collected a tremendous amount of data that you're all welcome to take a look at if you have an interest. Voices from the Frontline lives as a PDF on Google, so you can just go ahead and Google it. And so 524 survey respondents from 5 states cited their knowledge of 563 cases of known forced marriage. I was quite unprepared for that. I was quite shocked by those numbers. And these survey respondents were frontline practitioners, typically domestic violence service providers, They were refugee service providers, and a large number of them were actual survivors of forced marriage. We took 52 case studies that Ganga Shakti received, and we analyzed them, and you can see the data in the paper, as well as doing 22 interviews with frontline responders. And you can see some of the other numbers on the right side of the screen. So just in brief, major recommendations from this study, which was very unique. There's very little data on this issue in the United States. The Tahiri Justice Center has been a pioneer in this field, and they had done sort of the first study on this issue. And this study sort of furthered the understanding of forced marriage. And you can clearly see at the bottom there that what everyone really wanted to see was raising awareness of forced marriage because of the very, very poor understanding that, that abounds. So the forced marriage continuum is something that is in Voices from the Front Line. It's something that I developed. And it is being used by several nonprofit organizations during their case intake sessions. And it's quite interesting. It sort of shows you one possible interpretation of how an arranged marriage could turn into a forced marriage. This is not, the one interpretation. There are, I think, 1,000 different ways this can happen, but this is just sort of my interpretation. And service providers have found this very helpful when they're doing intake sessions with survivors. And here's some data for you in terms of, I skipped one slide. Types of violence used and the impact on victims of forced marriage. So the data that I collected speaks to all of these different types and forms of violence. So it's quite horrific. We're not just talking about sort of psychological, emotional, which is no less worrying, but we had data on reported cases of attempted suicide, actual suicide. I mean, it is quite extreme, the kind of data that we uncovered. And then here are some potential warning signs and indicators. The United Kingdom has done a tremendous amount of work on this issue and has put all kinds of civil remedies in place, and really is a wonderful model, I think, for us to learn from. So that's my sort of my overview for you on forced marriage in the United States. And I just want to talk a little bit about the initiative on violence against women that I lead at the Carr Center at the Harvard Kennedy School. So this is a pure research initiative that started about 2.5 years ago. I came to Harvard because of my paper, The Voices from the Front Line. And there I met two people, Lisa Shannon and Dr. Charlie Clemens, who were very passionate about the unfortunate normative gaps that exist in the global framework on violence against women. And they were very keen to examine the legal and implementation gaps. So since forced marriage in the US, I think, is a great example and a great illustration of both the legal and implementation gap, I was quite fascinated by the work and took it on. And so what we did was quite interesting and quite a journey over the last 2.5 years. We have reached out to, I would say, over 100 universities and really sort of done collaborative research projects with a wide number of law schools from around the world to understand what kind of access to justice issues do survivors face on the ground. What are the legal and implementation gaps on the ground in different countries? And if anyone has an interest, you can read all of that research. It's available on the Carr Center website under the Initiative on Violence Against Women. So we also built something called VOICE, the Violence Against Women Organizational Information System. And what that is basically is we mapped all the different violence against women organizations worldwide. We're not quite done yet. It's quite a task. But we thought it was really important to understand who are the actors, who are the service providers at the grassroots level, at the national, the regional, and international level. And I'll get to why in a minute. I already talked about the Global Research Engagement Strategy, which was the research with the universities. The last piece, the working group formation, has resulted in the Every Woman Everywhere Coalition that you heard about in the introduction. And this is a very, very interesting global working group that we developed from scratch. And today we have about 120 frontline practitioners, survivors who are working in the field, human rights attorneys, advocates, and policy people, all who are working together from over 75 countries to explore and develop a global treaty on violence against women. So, it's been quite an interesting endeavor, very, very productive. And you can see some numbers here. They're already dated. This slide is a little dated. It says 62 members, but we have doubled that. So we have 120, as I said earlier. So, I think what is really important to stress here is what the Every Woman Everywhere Coalition has come to understand is that not only is there a clear normative gap, the CEDAW being a very important foundational framework certainly endeavors to address violence against women, but it is for the most part housed in a general recommendation, and it is housed under the framework of discrimination. So we've looked very carefully at the CEDAW, at other regional conventions like the Istanbul Convention in Europe, the Belém Convention in Latin America, the Maputo Protocol in Africa, to really understand how are these frameworks being used, what are the access to justice issues continue to be, and what kinds of cases are being tried. And clearly the Latin American system, the Inter-American human rights system there is extremely functional and does a really nice job of bringing cases forward and hearing them and trying them. So we've done a lot of work to understand what the normative gaps are in the existing international legal frameworks, and specifically to address gaps in protection, prevention, and accountability on violence against women. In order for these three regional systems to reinforce universal human rights standards, it is essential that we have some kind of a global, legally binding framework on violence against women. There is an accountability issue out there, and there is definitely an access to justice issue that is very difficult to overcome. So in the work that we do, continuing this exploration of a global treaty, we don't know if it will take the form of a standalone convention. We don't know if it will take the form of an additional protocol on CEDAW. Really, the goal here is to do a very large-scale global consultation, which we're doing currently, which involves over 1,000 frontline practitioners and survivors, and really get their feedback and their insights on what would make, what needs to be in a treaty for it to be meaningful to violence, for it to be meaningful to women and girls on the ground, which is a very different process and approach than what has come before. And many of you might be familiar with the former UN rapporteur, Rashida Manjoo, who has spoken here previously at this venue and has done an incredible amount of work on this. Certainly we heed her call to action, and if any of you are interested and would like to read more about this, I would encourage you to read her reports and her papers because there's an incredible amount of detail and information that you can glean on the normative gaps and the need for this international legally binding framework. Thank you.
Thank you, Ms. Sri. Thank you, all of you. I have found all of these remarks incredibly interesting and informative. I know it's late, but I'm also aware that you may have questions. And before we get into questions from the audience, I'm going to let Caitlin Thomas take the floor and raise maybe some questions of her own or any other thoughts that she might have.
Microphone, good. I just want to follow up with the last comments that Vidya made. A separate convention on violence against women. For those of you who are not aware of the CEDAW convention stipulations concerning violence against women, has the greatest impact, the greatest teeth to it, is included in General Recommendation 19. It's not in the body of the convention at all. It's in a recommendation. And the way in which the recommendation can be enforced is through optional for the reason that ratified by every, and indeed it hasn't been. But there are arguments have been made. This mechanism for addressing violence against women, it hasn't been ways in which state recommendations. That's why there are a number of women and organizations that have been present deals with violence against women. There are some regional treaties that violence against women. That has been used as a prototype for a new convention. However, there are some people who have said that it's not a good idea to go forward with the new convention. Arguments that they raise, and this is what I would ask best, is that the countries that most need to adhere to these recommendations are not likely to accept stiffer recommendations. They're likely to use reservations as a way to that's what they're doing on the sea law today. And they feel, these women, that would probably be so included that it would be even worse than sticking to the optimal protocol of the sea law commission. So I'd like Vidya to address some of those arguments that have been raised because there was a very stiff argument on both sides of this issue 2 years ago here at the Bar Association with speakers very forcefully both sides.
Absolutely. Can you all hear me? Okay, thank you. Yeah, and there continues to be, I think, stiff arguments on both sides. The way we are addressing some of this debate is through our process. And I spoke to that briefly, but I can elaborate on it some more. We have approached this as a very broad-based, grassroots, sort of ground-up approach. And we have very intentionally looked for and identified survivors of violence that are working in the field. And we do feel that that is one of the huge voids in the current framework, and one of the reasons for many of the problems, including the fact that it is cumbersome and hard to use and hard to access and hard to understand. There's an absence of quality survivor engagement. Survivors are not being consulted systematically. I know that it's difficult to do. I know that there are limitations and challenges with that, but we have developed a survivor pilot consultation model at the Kennedy School that we feel kind of really meets, the tests of rigor that we've imposed on it. So, we're addressing quite a bit of the argument through simply process, and we are working very, very hard on engaging different women, experts and advocates and activists from many, many different countries. And we have found a tremendous response from women in the East and the South. And I can tell you that they're attorneys, they're human rights attorneys, very knowledgeable, very active, and they don't feel heard. They do feel left out of this global conversation. So I think that, we've really touched on a nerve, and I think this process and this approach is very, very different. It's quite radical, we feel that this kind of engagement will help to build an awareness-raising movement slowly, very slowly. We realize this is very much an uphill task. It's probably several mountains that we're trying to climb simultaneously. But we do know that awareness raising, advocacy is as important as that end result. So we're going about it a certain way. The other piece of this is the research that we started at the Kennedy School, which again was approached in a very specific way. We reached out to universities and law professors, women who were publishing on this issue, interested in this issue. And again, it was a very grassroots-driven approach. There were teams of law students who joined the research and did a wide variety of research that all of you can access. So this kind of process really hasn't been attempted before. Rashida has been quite excited by this momentum and the way we're going about doing this. I'm not giving you the legal expert answer. I'm giving you more of an advocacy answer. But that is how we feel, we're distinguishing the work that we're doing.
Thank you very much. I have my next question is for Shazia. I would like you to comment a little bit more about the efforts that are going forth to have a woman named Secretary General. Can you tell us a little bit about what you're doing and who the likely candidates might be?
Sure. So really in early spring this year, two different movements started to campaign for a woman. At the level of governments, the Colombian government put together a group of friends, which means countries that are in favor of having a woman SG, and 49 countries are members of that group. And they started to lobby within the General Assembly that there needs to be some direct effort towards ensuring that women are seriously considered, which they have never been in the past. In the past, only 2 women were ever officially nominated. Vijayalakshmi Pandit of India was nominated by the USSR, and the President of Latvia was nominated at some later stage. But they were never seriously considered by the Security Council. The decision itself is made by the Security Council and generally done in a behind-the-scenes process. However, this year, 2 other things happened at the same time which have opened the process. One is that civil society came together to insist that there be more transparency to the election process this time. And a group of women, of which I am a member, formed an NGO called Woman SG in addition to advocate for a woman to start putting up names and CVs of women who are possibly eligible and have the qualifications so that no one would turn around and say that we can't find a qualified woman. So as a result of these efforts, what has happened is that for the first time, there is an open nomination process led by the General Assembly President. 7 candidates have publicly filed with their governments having sent their nomination. 3 of them are women, and this is really unprecedented in the UN system. There are going to be public hearings held by the General Assembly from at least the publicly nominated candidates. They're trying to work out the logistics as to whether the dates suit all of them. At the same time, unfortunately, power being the way it is, since the Security Council has the power to make the decision, and the Permanent 5 particularly do, they have insisted that the informal channel they normally use remain open. So that while there is this formal nomination process in which people are dutifully filing their nominations, the back door continues to be open, i.e. there is no final deadline by which you have to put in your nominations. The Security Council will begin discussing them in July. They could take till the very last minute to throw in a name that hasn't actually been filed. Of the 3 women who are candidates, all 3 are from Eastern Europe, partly because under regional rotation, it is Eastern Europe's turn. If for some reason none of the 3 find, that all 5 permanent members of the Security Council are in agreement on their name, then they may open the regional rotation to include Latin America, which has had only 1 Secretary General so far. But of these 3, the The three are Irina Bokova of Bulgaria, who is the Director General of UNESCO, Vesna Pusic, former Foreign Minister and Deputy Prime Minister of Croatia, and Natalia German, who is current Deputy Prime Minister of Moldova. What we hear is that from Latin America, Susana Malcora, who is the Argentine foreign minister, is preparing to nominate if, it's open to them. At the same time, Helen Clark, who's currently the head of UNDP, is an undeclared candidate. So she hasn't filed formally, but there is considerable interest on her part also in the job. And there are people whose names are being mentioned, in the corridors. It's not really clear where that goes. The other thing that I think which could affect the final choice, and this is just my opinion, it isn't necessarily others' opinion, I think if the process is left with the Security Council being the institution that has to vote, out of the 15 members, 9 have to vote for the candidate, including all permanent 5. If the Security Council is the only institution that has to vote, it may be easier for a woman to be able to get the nomination because you have 15 governments that you have to persuade. If you end up with the choice going to the General Assembly with the Security Council sending more than one name, one man, one woman, it will be a major hurdle campaign for the woman because convincing 193 governments, many of whom have not had women in senior leadership, could be a very difficult challenge to gather the required 2/3 votes. So these women are having to run 2 simultaneous campaigns. They are sort of campaigning with the Security Council. At the same time, they're beginning to campaign with the General Assembly. And I can tell you, after I was Secretary General of PGA, I was put up by Pakistan to be the Secretary General of the Inter-Parliamentary Union, which is the largest parliamentary body in Geneva. I ended up being the runner-up to the deputy who was from Africa. It was extremely difficult because as the Asian candidate, I had to travel from New Zealand, Australia, a range of countries along that belt. The amount of physical effort required in a global campaign is extremely difficult. So not only do you have to be nominated by your government has to put out a huge amount of money, and they have to put all their foreign ministries' offices behind you for that campaign. It's not enough just for them to cast the ballot and say, yeah, we've nominated her. So we'll see. But I think clearly one thing that all of us in this room can do is to really ensure that our government here in the United States for the first time does push for a woman. And it's an interesting thing because I often hear people at the UN say, well, but she has to be really qualified, equally qualified. And I say, no, she has to be even more qualified, and they are out there. Here's the list. It requires an affirmative action step, really. It requires the governments to say, it's time, we want a woman, and in fact, even if we send 2 names to the General Assembly, we will send the names of 2 women. So that this time there really needs to be that level of commitment. And what effect it will have a ripple effect across the system. The UN right now has about 41% or so women working within the UN system, but mostly at junior positions. At the Under-Secretary General level, only 8% are women. That's the second level after the Secretary General. Among the peacekeepers, only 3% are women. Heads of peacekeeping mission, there are only 5 heads of peacekeeping missions, and one of them is a Norwegian leading the peacekeeping mission in Cyprus, which is, probably not doing very much. So there is a huge effect that it would have to have the most senior peace and security job in the world held by a woman.
Thank you. Really out of time, but I have one brief question to ask of, I guess, Karen, we can't ask you because you're leaving.
She has to make a train.
Sorry.
Sounds like.
Thank you for being here.
Thank
So,
you for having me. It's a pleasure. Apologies, I'm being rude leaving early.
no, it's past time. One brief question for Janet, since she is here. What can the Bar Association do to help your program?
Well, of course, that takes a longer answer and everyone's tired. But the first thing you could do is the Bar Association, both many committees, the International Law Umbrella Group of Committees, the UN Association Committee, the ICC Interest Group, the Women, should file an amicus brief with the prosecutor of the ICC to support the ICC opening an investigation of ISIS genocide of the Yazidis, and to emphasize in that brief the gender crimes of genocide that have never been enforced and that provide protection to women that the world is not aware of. Now, two Yazidi groups and the regional government of Kurdistan have filed an application with the prosecutor to have ISIS investigated, and they're being represented by former chief prosecutor of the ICC, Luis Ocampo. So you're in very good company to support Luis Ocampo in his efforts, and I think as shown how the City Bar led the effort among legal groups to get Geneva Conventions recognized as applying to war rape victims, that you could urge other bar associations, start with our list, to join that in the, and it would raise awareness of genocide. It would raise awareness that the ICC has to be accessed in ways that you may not think of, but it has jurisdiction, and that justice for crimes of genocide is mandatory for states to take up, and this is an avenue that states should be obliged to support as supporting their duty to do all that's possible to punish genocide.
That's a very direct answer. We have our work cut out for us. Other questions? Yes. I don't know if a mic is coming.
Sure, I can bring a mic.
I think you'll do okay on your own.
Yes.
The mic. Ms. Sri, I was very moved to hear your story, and I was appalled to hear that this is happening right here in New York City. My question is, for women and girls facing that situation today, what resources, if any, are available? For example, if the girl is still in school, can she go to a teacher or a counselor? If she's not in school, can she go to the police station? Where can she find help? And what can we do to, if there are no resources yet, what can we do to help?
Sure. So girls are going to their teachers and their guidance counselors. They're going to emergency rooms, they're going to their doctors, and that's how these cases are coming to light. You know, slowly the domestic violence organizations and different community organizations are learning about this issue, becoming more comfortable with it, and providing resources. You know, Ganga Shakti is a national, you know, provider of services and referrals to services. The Tahiri Justice Center in Washington, D.C. Has been a pioneer on this issue and is very, very good at connecting women and girls all over the country with legal aid and all kinds of different services. So there is a handful of us right now, and unfortunately, you know, if a girl or a young woman or an older woman, you know, goes somewhere where they don't understand this issue, it can become very complicated very quickly. There really is no statute on the books for this. There are about 8 states with some laws on the books, but they're all over 100 years old, and no prosecutions have been brought. So, you know, from a legal infrastructure, we really don't have one. From a implementation service infrastructure, we really don't have one. These girls are using domestic violence resources, which are not the same.
Yeah, I think at this point we're running a little bit past 8:30.
We are. Is
Yeah,
that a problem?
yeah, indeed.
Well, does anybody, how about one more?
Okay, let's take one more
Does anybody else
question.
have a question? Maybe there aren't any. maybe we're done.
We can also invite you to join us afterwards, if you would, for a glass of cold ice water in our reception area, and you can ask all the questions that you'd like to ask.
Well, so it looks as if our evening program is over. I want to thank all the speakers again. I've said before, and I say again, I found it all very, very interesting and informative. Thank you all for coming.